All rise. The Court of Appeals, Division 1 is now in session.
Please be seated. Welcome. We are here in our case number, CV 190504, Florence v. Florence Copper. Counsel, you each have 20 minutes for your argument. The appellant, you can reserve time. I would just ask that you keep that yourself. So it's a little different. If you could remain at your table.
Sorry, you went down the podium while you were down.
Okay. Put my glasses on. All right. That caught me in the last one, so I guess we're back to that. So just if you can tell me your client's name and your name, that would be greatly appreciated.
Send me a bill.
And with that, let's begin.
Thank you, Your Honor. I'm Catherine Bowman. May I take my mask off for the
Please.
purpose of the
Please,
argument? Thank you.
please.
All the new rules. My name is Catherine Bowman. I'm the attorney for the town of Florence in this matter. I appreciate the opportunity to talk to the court in person. The town's position in this case is that through its zoning powers, which is a police power that's delegated to the town through the Title IX from the state, it enacted an ordinance that made mining on the Florence Copper property illegal. That ordinance was enacted in accordance with the town's zoning laws, which were enacted, again, consistent with the direction from the state that towns that are going to enforce zoning laws develop a zoning procedure.
Isn't there also a statute on development agreements?
There are statutes on development agreements, which are obviously contracts, and there are provisions in this particular development agreement that put the property owner, Mr. Harrison Merrill, on notice that his property would be subject to the town zoning code.
But let's, I guess, and we'll take that, we'll walk through it, but that initial point, which is, I'm getting the sense that you're saying the town's zoning power is supreme in some way to its authority to enter into a development agreement when they're both statutes.
They are both statutes, Your Honor, but the town could never enter into a development agreement that would be inconsistent with its zoning powers, because the zoning powers, when they're delegated from the legislature, have to be specifically followed by the town in order for the town to meet its obligation of that delegation. So in this case, I believe that it is clear that there is no inconsistency between the town's enactment of these ordinances that made mining illegal and the development agreement, which is why the development agreement.
The development agreement specifically said mining will be allowed as a non-conforming use.
The development agreement did not say mining would be allowed as a non-conforming use.
The development plan is incorporated.
There was attached to it a plan that had mining as a non-conforming use. The reason why that is different, Your Honor, is because if that sentence had been written into the development agreement and the parties wanted to change that use on the property, they would have gone through the process of amending the actual development agreement. We see that.
So are you saying it's that's not the development agreement, the development plan? If you have something that's attached to an agreement, and the agreement says this is incorporated, and let's assume that it has all the terms, and so it's just really just a vehicle.
I'm sorry.
Then aren't those terms of the agreement?
They are terms of the agreement, Your Honor, but if I could say what is in the development agreement. So section 6 of the development agreement has a section called development plan. That section is what applies to the development plan. What the court did down below was apply paragraph 32, which applies to an amendment of the development agreement. What Mr. Merrill asked for and received as part of the development agreement was PUD zoning, PUD zoning. His Merrill Ranch property became a PUD district. Section 6 of the development agreement says that all ordinances that were currently in effect at the time that the development agreement was entered are effective. Under the-
Let me stop you for a second, because I feel like we switched the argument. You were originally arguing that the town could not have entered into a development agreement or plan or anything that would take away their zoning rights. Now I'm hearing you argue that the agreement they entered into didn't actually take away their zoning rights.
Didn't actually, I'm sorry?
Didn't actually take away their zoning.
It didn't take away their zoning
So let's
rights.
start with just point one then.
Great.
Could the town have entered into it under 90 ARS 9-500 A through D, entered into an agreement where they said, Merrill, you get to keep your mining rights even if we later change our mind and decide you don't get to mine? Could they have entered into that agreement?
They could have entered into that agreement.
Okay.
And
So-
consistent with,
So you're not arguing that it's a violation of separation of powers and per se just not a possible?
it is in violation of separation of powers for the court to not enforce the valid zoning ordinance that was enacted in accordance with both this development agreement and the town's
That begs the
zoning.
question of whether it violated the agreement or not. You're conceding that you could enter into an agreement that the town would waive its right to change that later pursuant to 9-500.
Yes.
So
Okay.
what's why would anyone ever enter into a development agreement with your client if they can unilaterally change their mind as circumstances warrant?
And I'm sorry, Your Honor, I can't see the clock at all from here, so that caused,
1433.
I'm sorry?
You got 1430.
Okay, thank you. Your Honor, here's what the problem is. We're calling this, or Florence Copper is calling this, some unilateral act on behalf of the town.
Yeah, I don't want to get onto that. What I want to know, what's the value of a development agreement?
The value of the development agreement in this case,
Just generally, why does it exist?
it exists so both the property owner and the town can work together to come up with the processes that will govern that piece of property. And the town will know what's going to happen, as will the developer.
Okay, so come up with, what your words were, the what?
It can be processes, and it may help if the court would let me say what I believe is in the development agreement, because it shows why it is that the development agreement is helpful. When Mr. Merrill entered into the town through this annexation agreement, he wanted PUD zoning. The PUD zoning has with it a very flexible process where when you get approval of a development plan from the town, you can know that you can develop as consistent with that development plan. That's what he wanted in this agreement, and that's what he received. So
Right,
that
I
is
know.
one of the advantages. The development agreement says all ordinances apply, and the PUD district ordinances, which are in section 150.069, say that those ordinances apply to all PUD district zoning. So at the time he enters this development agreement, he knows he has requested PUD district zoning, and the ordinances that are from the town are going to apply to his zoning. That zoning law of the town, section 150.069, has the procedures in it whereby a party amends their development plan. It does not include recording. It does not include anything having to do with the development agreement.
Let's back up and just simplify it. So we have a contract at the beginning here. It's called the development agreement created by the legislature Would you agree with me that there was a development agreement that had a development plan attached in 2003?
Correct.
Okay, and there were terms in that agreement, right? And there was, would you agree that there were twin value principles? I think for Mr. Merrill, one was copper and one was residential housing. Would you agree with that?
I would not. Mr. Merrill, this is another issue in this case, Your Honor. Mr. Merrill,
An issue of fact?
in his affidavit, says, in 2003, I never thought about mining. I didn't talk to the town about mining. I didn't talk to the town when I did this development agreement. That's in his affidavit. In his affidavit in 2007, he says, I didn't talk to the town about mining. And in between, in his deposition, in portions that have been left out in some of the quotes that counsel has used, he says, we were not going to mine. Housing was what was important. If a mining company was going to buy this land, then they would figure out whether or not they had the right to mine. He
And
said,
the only evidence of that in the record, you're telling me? There's no, I mean, now you're getting into questions of fact, and this is the Court of Appeals.
well, yes, Your Honor, I'm getting into questions of fact, but the affidavit is attached to the brief that was filed by counsel. And it says something that's inconsistent with that. But for the purposes of trying to get to how this development agreement works and how it is consistent with the town's zoning laws, the town, when it entered the agreement, didn't give up the right for the property to be zoned in accordance with the zoning laws that applied at the time. And we see that in Section 6. Section 6 says the town on its own will not institute any type of ordinances or zoning against the property. But it talks about the fact that the property owner can agree to change the development plan. Here, Mr. Merrill came forward and filed an amendment to his development plan. And it was looked at by the town. There were public meetings on this development plan that no longer included any reference to mining.
Let me ask you, what was the consideration for the development agreement on each end?
The town agreed to the conditions of the development agreement, and Mr. Merrill agreed to annex into the town.
Okay. And was there a term in the development agreement that would allow a non-conforming use of copper mining?
In the development plan, there was, and if I may say, the development agreement gives a vested right to the developer to develop in accordance with that development plan. There is nothing in either the development plan or the development agreement that elevates this use of mining to something different than everything else that's in the development plan. So for example, Pulte owns now a portion of this property that's covered by this agreement. In the 2003 development plan, Pulte could have a golf course. In the 2007 development plan, the golf course was removed. In 2003, they had a vested right to build a golf course under that development plan. I don't think the court would say that Pulte would be entitled to a trial to determine whether or not Mr. Merrill intended to remove that golf course from the new development plan that he asked the town to enact. The town didn't do anything to Mr. Merrill or his property. The court says his lawyers wrote the agreements, his lawyers wrote the ordinance. He was asking to do something different on his property. And in accordance with the development agreement, which gave him control over what he wanted to do on his property, the town enacted that ordinance and enacted that development plan.
I want to make sure I'm understanding your arguments, because I think I am. I think I'm tracking what you're saying. But so you agree that in 2003, the plan as attached to the agreement allowed mining as a non-conforming use.
Correct.
And that under ARS 9500, whatever the statute is, that's a vested right that he had at that time.
And it was vested because the contract in fact said he had a vested right to develop in accordance with that development plan.
And so your argument is that though when he came forward in 2007 and agreed or proposed a development plan, that he then waived or forfeited whatever rights he had in the agreement and the statute prior to 2007.
He didn't waive it. What I'm saying is that when he amends the development plan, he is doing that as under the town zoning law, because that's what even his own development agreement says those ordinances apply.
Okay.
So he has PUD zoning. He still has to follow the ordinances with respect to PUD zoning. So he has the
But it's the
2000.
act of coming forward and proposing an amendment to the plan that, and having that amendment approved by the town, that therefore he lost his rights to mining under the original plan as attached to the agreement.
For two reasons, Your Honor. One, because the ordinance that he wrote, that the town enacted, said that 2007 plan superseded all other plans. The court below does not deal with that in its decision at all. It specifically says it superseded it, and it was the property owner who asked that the 2007 plan supersede the 2003 plan. We're in this situation where for some reason we're saying one thing, not the golf course, not the height of buildings, not how many buildings there can be, but this one thing of mining somehow still survives the property owner's request to have a new development plan, which is consistent with all of the inequities of the development plan, and then they leave the non-conforming use out. And if I can say, because the mine is one of the only things that's listed as a non-conforming use, there's actually less right for the developer to develop in accordance with that. Because the non-conforming use statutes were exempted in some ways, having to do with they didn't have to mine within 180 days. But it didn't exempt it from all law related to non-conforming use.
You've got 422 left.
Okay. And I just want to bring this up because this is Grady Gamage, and his report is in as Exhibit 78, and he retired. It's a very important point because even though he may have not had to mine in order to keep his non-conforming use, the law doesn't like non-conforming uses. And he did nothing to preserve it when he asked the development plan to be changed in 2007.
Right, but are we talking about mutual assent? And we even have this filing requirement for a county. Give me, if you can, and I'll get a pencil and I'll write down everything, all the evidence that shows there was mutual assent. I know there was a council person that said, well, I didn't raise it because I didn't want him to know he was waiving it. That sounds like the opposite to me of mutual assent. But what is it? I mean, are you saying that the word supersede in this document is mutual assent?
Your Honor, I would ask that you take a look at Exhibit 17, which are all the emails back and forth between his lawyers and the town where they are negotiating what this says is mutual assent. What we're saying.
Word search on that for copper or mining.
Well, or golf course, Your Honor, because
I'm not sure what the golf course is. I didn't see that argued. But if I do those two words, mining and copper, and all that string of emails, how many hits do I get?
none, because that's not how the zoning process works. The zoning process says, and the zoning law says in 150.069, if you have PUD district zoning, which Mr. Merrill received as part of this development agreement, everything that you want to do on that property needs to be in a development plan. You can only legally use your property in accordance with the development plan.
There's no mutual assent requirement because of this zoning?
No, Your Honor, because all of that was in a development plan, and the document in Section 6 tells you how to amend a development plan, and it doesn't require you to go through each item and say, I don't want this anymore.
So the moral of the story is if you're going to enter a development agreement, put all the terms that matter in the agreement and not in the development plan?
No, Your Honor, because number one, the property owner has to decide what matters. The development plan gives the property owner flexibility to change what it is that they want to do. That's what Mr. Merrill wanted. He did not want to. If you look at exhibit number 205, and this is cited actually by the court in its opinion. This is an email to the town from Mr. Merrill's lawyers. It asks, why are they holding back, meaning the town, holding us back from getting our PUD amendment processed as a standalone zoning document? They know that the PUD plan zoning is a standalone document. The fact that you attached it to the development agreement doesn't change that. What the development agreement did was give him PUD zoning, which required there to be an approved development plan. He got one in Exhibit B because that's the one he wanted in 2003. He himself asked that his zoning be changed, and he wrote the development plan in accordance with statutes that tell him that he needs to put in the uses that he wants to have on his property. And the court says they intentionally left the mining out.
So I said I was going to do this, but you have 32 seconds. Do you want to keep that for rebuttal?
Sure.
Can you put 32 seconds on that?
Your Honor, I moved the microphone. The council favor.
Please.
Yes.
Mr. Eckstein.
May it please the court, Tim Eckstein, on behalf of Florence Copper. Arizona law allows for development agreements. The court's questions to counsel for the town elicited responses from her on recognize that principle. It's ARS 9500-05. And those are specialized contracts that create vested rights with respect to property to develop that property. Those rights run with the land, and they can't be impaired without the consent of the property owner. The statutes are clear on that. The purpose of those agreements is to inoculate property owners from changes in the direction of the political wind. So a new governing body comes into town, so to speak, and they decide they want to zone because they don't like the way a particular agreement allows developers to do things, and so they just zone away whatever those rights were. Because of this statute, they can't do that. They can't do it without the consent of that property owner. It's undisputed in this case, the town of Florence and the prior property owner, Harrison Merrill, agreed in 2003 to a development agreement that would annex Merrill's property, and he would receive certain vested rights, including the non-conforming right to conduct mining operations in what's called the BHP copper mine overlay. Some of those rights are described in an attachment, a development plan. The court recognized, but Weinstein recognized, that plan is incorporated in its entirety into the agreement. That's critical. There's no sort of separate distinction that these are terms that are somehow given lesser effect than the other terms in the agreement.
So Mr. Eckstein, let's talk about the clash of development plans, 2003 circa and 2007, right? And so I think your argument was that that's consistent, and what prevails in 2000 from the 2003 agreement are these vested rights, and then and everything else you look to the 2007 plan. Is that accurate?
That's correct.
So give me some examples of things that would govern in the 2007 plan in place of the 2003 plan.
It is everything in the 2007 plan, but for the mining rights that are preserved from the 2003 plan as incorporated into the agreement. And I think the court doesn't need to get past this last point, which is it is stipulated. There's no dispute that the agreement was never amended. And absent an amendment to that agreement, because of these other provisions, you've got the law, you've got the agreement, it's a vested right to mine the property. That agreement is never amended. I don't think the court needs to go past that to affirm the decision of the trial court. Here.
So was the 2007 rezoning and development plan, there's nothing in there that changed terms from the 2003 development plan?
There are changes to the terms from the 2000.
So that was an amendment or a change, or so there is a change. You're just saying it doesn't extend to copper mining.
That's correct. It can change the location of items in that plan. I think in this instance, it also increased residential density that's allowed as part of development. What it cannot do is impair those rights that were established in the original agreement. And that is what the town is arguing for here. Not so much a change to the way the plan was to be structured or the property developed, but an impairment of those rights, which is specifically prohibited by the statute and by the development agreement itself.
Mr. Exline, 9-500-05C says that you can impair those rights by mutual consent of the parties. And as I heard your colleague's argument is, we should find that his proposal of a new plan that used the word supersede is evidence of the mutual consent of the parties to supersede that prior plan that preserved copper mining.
That's what she's arguing. I'll turn back to the substance of that question. I just first want to observe that wasn't an issue raised in the appeal. The closest I think the town got to that was the town's arguments for the separation of powers. You can't have two development plans. The trial court eviscerated the public participation zoning requirements. And then this last issue, the trial court erred as a matter of law in its contract interpretation when it determined that the 2003 PUD could not be amended without amending the development.
Wasn't that the whole purpose of the evidentiary hearing? To find out precisely the answer to Judge Morse's question, which is whether the supersede, an evidentiary hearing. What are the facts? What does the record say about mutual assent? And I guess the court found there was evidence to support none.
Yeah, so following a 6-day trial with 250 exhibits and 10 witnesses and 4 other witnesses whose deposition testimony was entered into evidence, the court made extensive factual findings that are subject to clear error review. And I don't see an argument in the briefing from the town contesting that any of those facts were clearly erroneous. But among those facts are the fact that the development agreement was never amended. That when you look substantively at everything that Harrison Merrill did during that period of time, as it related to mining on the property, none of it makes sense if it's somebody who thinks he's forfeiting his right to mine. He's actively trying to sell the property to mining companies. He's keeping in place the environmental permits that he had. He's not undertaking any of the acts one would need to undertake to formally close the mine.
As a matter of law, though, I mean, I agree with you about the court's extensive fact finding and at least that the court found there wasn't mutual consent there. But don't we just say when you sign an agreement that says you supersede a prior agreement, in this case, the plan superseded the prior plan, why wouldn't that be the be all and end all for us?
So the 2007 plan is not an agreement. He engaged as one of the parties who helped sort of develop the material terms of that, but it's not an agreement, and it's certainly not an agreement that in any way can impair the rights from the 2003 agreement, which has a specific and concrete term regarding amendment. But an amendment needs to be in writing, agreed to by both parties, and recorded within 10 days. None of those things happen.
So, but I think Judge Morse, we have this vehicle, this development agreement, and then we have the terms that matter in this development plan. And you have something in 2017 saying that's no longer there, just the 2003 is now the 2007, and we're going to use this supersede. And so, how is that inconsistent with the rights? If you assume that there's an inextricably tethered a bond between development agreement and development plan, and you're swapping out one for the other with a word like supersede, why isn't that consistent?
Because I think you would still need to establish that there was a specific intent on the part of Harrison Merrill to forfeit that right. Counsel for the town was referring to paragraph 6 from the development agreement. Among the terms of paragraph 6 and 6F, the town can't apply zoning changes, and that's what this is. It's a zoning change that would change, alter, impair, prevent, diminish, delay, or otherwise impact the development or use of the property as set forth in the 2003 development plan, except as specifically agreed in writing by the owner. That specific agreement relates directly to those rights that are vested in the 2003 agreement. And again, this is not an argument they raised in their briefing, and it's not an argument they should have presented until today.
And I think you'd argue that the word supersede in the context of all these agreements is at best ambiguous. You had an evidentiary hearing, and so this court is only interested in looking at a record and seeing if there's reasonable evidence to support the conclusion, the judge's conclusion.
Absolutely. And there's not a challenge to any of those factual findings as having been clearly erroneous. I think short of that, I don't know how this court can not affirm the judgment of the trial court. I don't know if this argument is still viable. I don't know if counsel for the town waived it, but I'll turn briefly to the separation of powers piece.
I heard counsel acknowledge that if the original agreement had not been amended, that it would be fine for the city to waive its rights. So I don't know if you need to turn to that or not.
Okay. The town's argument that the trial court's ruling eviscerated the public hearing participation process. The cases cited by the town deal with the procedures as they relate to public hearings and not any of the substance that results from those hearings. There is no legal theory that is raised by the town to suggest that, first of all, anyone didn't comply with those procedures as set forth by statute and rule. The town certainly did. And to the extent there is an argument that the town was somehow misled, or the town citizens were somehow misled by the adoption of the 2007 agreement, followed by the court decision that the mining is a preserved, non-conforming use, we would argue that the townspeople were not misled at all. In fact, mining was not discussed in 2007. If you've done Weinsweiger's question about, I think it was Exhibit 17, a series of emails going back and forth between the party, you're not going to find the word copper, you're not going to find the word mining, or anything possibly connecting those in any of the parties' discussions in 2007. This is the point that the trial court lays out as an objective matter supporting this conclusion that there was no agreement, there was no consent to any impairment of the right to mine, objectively speaking. Subjectively speaking, the town mayor at the time certainly thought that that's what Harrison Merrill believed. In his deposition, it was quoted in the briefs, the town mayor, when asked why he did not raise this question with Merrill about potentially giving up his right to mine, he said he didn't raise it because he didn't want Merrill to catch on that maybe he was potentially doing so. So clearly, the town also believed that Merrill was not consenting in any way to forfeiting those rights.
Or they thought he was, but he just didn't know it.
Well, I don't think you can consent without sort of knowledge of your consent or agreement to something. I think we've gone back and forth, but just to sort of put a fine point on the two PUD question. There are not two PUDs, and first of all, there's no legal impediment to there being two PUDs. It would certainly be impractical, and I wouldn't advise that any town have such a scheme in place, but they haven't cited any case or any statute that prohibits it. Putting that aside, the 2007 PUD is the operative document for the development of this property. That has been in place now since 2007. 2007 without confusion, without people not sure how to operate on it, because everybody's operated on it, with the preserved right of non-conforming use to mine as set forth in the 2003 agreement. There is no practical problem or sort of nightmare from a development perspective that would result and has resulted from.
Were there any other
the trial court's
non-conforming uses in that 2003 development plan?
There were, but mining, I think, was distinguished among them, certainly in at least a couple of provisions. One with respect to that other non-conforming uses, if they discontinued for a period of 180 days, they would be forfeited and a use would then have to conform with the development plan. That provision, there was an exception for mining rights such that there's not this 180-day requirement.
So the 2007 development plan wiped out all the non-conforming uses except for, is that the argument? Mining?
The only issue before the trial court, and the only issue I think before this court, is as it relates to mining itself. Theoretically, there could be other non-conforming uses, but that argument wasn't.
Well, I think what we're trying to decide is we have a succession of, I don't want to call them agreements, but development plans and what survives. And so I don't think it's unreasonable for this court to see what else was in that agreement and what else survived.
That is the only thing that is being argued before this court, that the right to mine survived. It is possible that some other party at some other time could come forward and raise such an argument, but I think there would be a number of impediments to that. So certainly the consistency with the agreement, the fact that the non-conforming use, because it wasn't, if it had discontinued for a period of 180 days or more, would have been forfeited by its terms, and I'm simply not aware of another non-conforming use.
What else could the town have done to accomplish what your client says they didn't accomplish?
By that you mean?
Well, so I think the argument, your client's argument, is that we have these requirements that your colleague's client has. Well, both of us have to satisfy in order to change the terms of our agreement. And so that leaves a room, something wasn't done. And so I'm asking you, what should have been done by the town that wasn't, that would get you all on the same page that we have an amendment?
An express amendment to the development agreement consistent with the terms of that agreement.
Right, so we have the rezoning and we have the word supersede. You're saying on top of that, to have a totally separate agreement titled what? Amendment to?
An amendment to the development agreement, as happened twice.
To the development.
If your client had signed the development plan in 2007 and it had been recorded within 10 days, would that have been sufficient?
I don't think so, unless it was intended by the parties at that point to be an amendment to the development agreement.
But at least they'd have a stronger argument if those two sub-requirements had been met.
They would, but I think you would still need to be able to demonstrate there was an intent to amend the agreement itself. But if the court has no further questions, I will cede the rest of my time to the office.
What about this remedy argument? Isn't that an advisory opinion? In case there's a breach at some point in the future, you guys don't worry, everything's taken care of. I'm going to rule on that.
It is not an advisory opinion. It is an interpretation of the agreement itself under the Declaratory Judgments Act that the trial court felt there was a basis to issue that decision based largely on the inconsistent statements of the town. At the oral argument on, I believe it was the second motion for summary judgment, town's council took the position that the town could be sued for breach of the agreement, but even should that happen, the town could go ahead and prohibit mining. Sort of a variant of the separation of powers, police powers argument as I understand it. So following the trial court's decision in January of 2019 asked the parties to resolve as many of the issues as possible. One of the counterclaims in this case was one for specific performance. So our client, Florence Copper, suggested a judgment that included the potential remedies of damages or specific performance. At oral argument on those specific remedies, the court asked the attorney for the town whether the town was in agreement with the notion that is now embedded in judgment, that one of the potential remedies the town could pursue was specific performance, and council agreed. That was something that could be pursued, and seemingly waiving it for appeal, yet it appears in the brief as something that is a live issue. But to substantively, it is certainly something that is allowed under the Declaratory Judgments Act. The court is simply interpreting the terms of an agreement and informing the parties that this is the court's reading of what those terms mean. And should there be a breach in the future, the town would have available whatever defenses it otherwise would have applicable to the entry of a judgment in favor of specific performance.
So
some other remedy.
doesn't that development where the town says, you know what, don't worry, doesn't that hurt your argument? Because there's no longer a disagreement for us to go to the court and say declaratory judgment, we have a and B, which one is right? Because now that doesn't exist anymore. So why does the court reach that if there is no such disagreement under the terms of the Declaratory Judgment Act?
The town has earlier taken the position that it sort of at some point backed away from it, but apparently has gone back to arguing that position that whether it's police power, separation of powers, somehow zoning power is supreme, such that it can do what it wants with respect to restricting through zoning Florence Copper's right to mine that property, and then just be sued for contract damages.
So you weren't comfortable with the vacillating position?
No, certainly based on the town's conduct and shifting positions over time.
Okay, thank you, Mr. Eckstein. Ms. Bowman.
Yes, Your Honor. I just asked the court to look at section 6B because there is this disconnect between this section 6, which is entitled Development Plan. The owner says the owner expects that amendments to the development plan will be necessary. The owner is saying the owner is going to want to make amendments. Under section 6,
6B of what?
6E of the development agreement. That's what I'm saying, Your Honor, is there's a section of the development agreement that tells you how to amend a development plan. And we keep talking about paragraph 32, which is how you amend a development agreement, and they are not the same. And so in section E, it says, regardless of other town requirements, the owner shall be only charged $3,000 for any planned unit development amendment, which is further evidence that how you're going to amend this development plan that the owner says in paragraph B, they're going to want to do from time to time, they may want to change the development plan. It tells you that the laws that are in existence at the time in paragraph 6A, that they apply.
To conclude, but go ahead.
Okay, and so what I say to the court is in exhibit 22 and bigger so that the court, on page 22, I'm sorry, of the court of the opening brief, there is a list of the appendices for both the 2003 and 2007 planned development amendments. This is it covers every single thing in 2007 that is covered in 2003. And that is because that is required by the zoning code in 150.069. It says if you're going to amend it, you have to cover all sections. So in 2003, there was a vested right to do everything on this list. In 2007, there's a vested right to do everything on this list. And there is nothing in the law or in the development agreement that allows one to survive the amendment that occurs in 2007, where it says this new list supersedes the other.
Okay, thank you very much, Ms. Bowman, Mr. Eckstein. Thank you both for your helpful arguments. We will take it under advisement and have something out in due course. And with that, we're adjourned.